Good afternoon, everyone. Good afternoon, everyone. Sorry for the technical difficulties. Again, my name is Kimberly Ballard. I'm a patent examiner in Technology Center 1600 at the United States Patent Office. I specialize in reviewing and examining inventions in the fields of neuroscience, protein-based therapeutics, and diagnostics. And as Caroline mentioned, I currently serve as an assistant regional outreach coordinator for the Elijah J. McCoy Midwest Regional Office. And so this afternoon, we're just going to give you a brief overview on intellectual property basics and some resources. Just like a fence that may be used to define the physical boundaries of a property that belongs to you, intellectual property defines the metes and bounds or the legal fence around intangible property, such as an idea. In other words, intellectual property is ownership of a concept or of an idea rather than ownership of a parcel of real estate or of an object. So IP rights allow us to protect and control how our inventions and distinctive names and brands, original writings and artwork are used. And they also provide us with guidelines for use of other people's intellectual property. Today, we're going to be looking at 4 basic categories of intellectual property. There are patents, copyrights, trademarks, and trade secrets. So patents can be either utility or design or plant patents. Utility patents protect inventions such as just as an iPod or chemical fertilizer or a method such as a method of treatment or a method of manipulating genetic traits in a mouse. And they're good for 20 years from the date of filing for a regular patent application. Design patents protect the way a product or an article looks, such as a distinctive type of electric guitar or a lamp, and protection lasts for 15 years from the date of issue. Plant patents are unique in that they they protect individually strains of asexually reproducing flowering plants, and their protection lasts for 20 years from the date of filing. An example of one is you may have seen recently in the grocery stores is a cosmic crisp apple from Washington State University. Next, we have copyrights. Copyrights protect original works of authorship, including literary, dramatic, musical, artistic, and other works fixed in a tangible medium. And their term of protection is typically for 70 years. However, some works can be for 95 years from publication and others from 120 years from their creation. Next, we have trade secrets. Trade secrets protect things such as formulas, methods, devices, or compilations of information, which are confidential and can be used to give business an advantage. An example would be the formula for Coca-Cola or the KFC recipe. And protection lasts as long as the information remains confidential and functions as a trade secret. And finally, we have trademarks. Trademarks protect words, symbols, logos, designs, or slogans that can identify and distinguish products or services, such as the Coca-Cola name and distinctive logo. Protection lasts as long as the mark is in continuous use in connection with the goods or services. So also note that you have to renew a trademark at year 6, and then at years 10 and every 10 years after. Oops. So again, patents, there we go. A patent is a property right. Patents can be used to protect new and inventive ideas, and they give the patent owner the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. And as I mentioned before, there is a limited term for a patent. Depending on the type of the patent, it's either 15 or 20 years. Patent protection is territorial, meaning the protection is limited to the territory in which your patent is granted, and there are no worldwide patents. So if you'd like protection outside of the United States, you'd have to file your application with each individual country. And oh, looks like James is blocked. Okay. So if you want protection in the US, you have to file with us at the US Patent Office. And again, you'd have to file with each individual patent office in different countries for protection in each of the different territories. And just want to note that, you know, the mission of the USPTO is to foster innovation. And in exchange for this disclosure of the invention, the patent office grants this limited protection of the rights for this invention to the inventor. And as a patent examiner, it's my job to ensure that the inventions that are disclosed with sufficient detail, and then they meet certain statutory requirements that are set by Congress, and that we follow, so that we have ideally the highest quality patents and that protect both the inventor and the public. Next, we have copyrights. So again, copyrights protect original works of authorship, including literary, dramatic, musical, artistic, and other works fixed in a tangible medium. Generally, again, their term is good for the life of the person who developed the IP plus 70 years. Things protected from copyright include songs, movies, books, sounds, software, and sculptures. A copyright is a bundle of rights that gives the owner the right to make copies, prepare derivative works of those copies, and distribute them, and perform the work publicly and display the work publicly. Now we have trade secrets we touched on. Trade secret is any information that derives economic value for being not publicly known or ascertainable. Trade secrets protect commercially valuable proprietary information that gives a competitive advantage. So it can be used to protect things such as customer lists, product formulations, patterns, methods, techniques, softwares, and search algorithms. So here's some trademark or trade secrets you might be familiar with. So the formula for Coca-Cola, KFC's original recipe, the lubricant formulation for WD-40, the antiseptic mouthwash of Listerine, the special sauce on the Big Mac, and the Krispy Kreme glazed donut recipe. Now, trade secrets are only as good for as long as they are secret and they're not discovered. So, of course, there are ways to lose a trade secret, such as failure to protect your trade secrets by failing to take adequate steps to prevent disclosure. Sometimes a owner of a company might accidentally let that secret slip, or they might not have established non-disclosure agreements with their contractors or employees. Another way to lose your trade secret is by reverse engineering. It might be possible, for example, without insider knowledge, for someone to reverse engineer and discover the trade secret, or simply by independent development. Sometimes someone without insider knowledge may be able to independently develop and discover the trade secret. And finally, we have trademarks. A trademark is a brand name. It's a trademark or service mark includes any word, name, symbol, device, sound, color, or any combination thereof, used or intended to be used to identify and distinguish the goods or services of one seller or provider from those of others, and to indicate the source of those goods or services. It is not a business license, so you have to check with your state or local regulations regarding requirements for business formation and operation. So here's some trademarks you might be familiar with, and in addition to these visual types of trademarks, non-symbol trademarks can include colors such as Barbie pink or Tiffany and Company's blue, the breathing sound of Darth Vader from Star Wars, and also the scent of Play-Doh. So now I'm just gonna touch on some USPTO resources that are available for applicants and that we'd like to make you aware of. So we have outreach services in each of our regional offices and also at headquarters. And the USPTO is open to the public. We are able to help individuals who come into the office, and we can sit down, you can sit down and speak with an examiner or a member of the staff for assistance. We also have interview rooms to conduct interviews with inventors and the examiners who are working on the cases. Office hours, of course, vary. You might want to check with your local, with the regional branch or the headquarters. And you can also sometimes partner with small business administrations, and they can assist you in helping finding the office hours for such. And we also offer many educational programs that are available online to the public for free. You can check our events page that has many different resource programs. So yeah, again, there's many different links that we have for inventors and entrepreneurs. For example, we have a whole web page devoted for entrepreneurs and inventors that can help get you started in terms of identifying what type of intellectual property you have. We have an IP identification tool, and it's basically just a few clicks, 6 questions, I believe, that gets you through for the part 1, and then it can identify resources for what you might need to further your invention or your idea. There are many different resources available for the small inventor and entrepreneur. So for example, this is one site I'd like to bring your attention to that is lots of different resources. You have things such as trademark basics, searching for trademarks, how to apply for a trademark and protect your trademark and maintain your registration. There's also links for patent basics, and again, how to apply, get assistance, and maintain your patent. Also, we have like pro se and pro bono resources for small businesses. There are certain income requirements, but typically for small businesses, that's usually quite reasonable and can be met. We have resources available for making patent searching easier, how to conduct a preliminary US patent search. And oh, hey, I think we have James available. James, do you want to take over?
Good afternoon. Can you hear me?
Yes.
Yep.
Okay. I apologize. I don't know what's going on with my computer. I don't know what's going on with the Zoom. The link just dropped me in. I don't know where we are in the presentation. I'm just coming in.
We are talking about patent searching.
Okay. Okay. Are we talking about the significance, or are we talking about the process?
Oh, the process, yeah. So just sharing some resources on how to conduct the resources we have at the patent office. We have some tutorials on how to start searching, some guidelines on how to start searching for patents.
Keep
There,
going. You finish this slide. Let me see
there. Yeah, so we have a 7-step strategy. It's a detailed handout on how, with examples and screenshots on how to design your search and go through the actual search process so you can find the best possible prior art. That prior art is something that we use to what we call what might have come before your invention. And that's what we as examiners would use to say whether or not your invention is novel or non-obvious. So it's in your best interest to find out what's available out there to begin with, because you don't want to try and patent something that's already been disclosed to the public, because that's not going to get you a patent. So you need to first find out what's out there and where your invention might fit that is outside of what's already been shown or disclosed to the public. So patent searching might also require an understanding of patent classification systems. We do now use a worldwide patent classification system, or CPC. It's called the Cooperative Patent Classification System. And there are resources at the Patent Office that can help you identify which classes of invention your ideas might fall in, so that you can perform the best possible prior art search. And all right, you want to take it from here?
next slide.
All right.
Okay, so what we have in front of us now is an example of a search and what you might be looking to search for. So in this diagram, you see that there's a coat or some type of covering for an animal. And what you would need to do is to go into exactly what the invention is. And what we want to do is to make this as easy as possible so that you don't have to have extensive training to be able to search for a particular invention. So the invention that you would be searching would be what you think you've invented and what's on your mind and what you think is a novel invention that you want to verify is novel. So we have what's called the Inventor Search Assistance tool, and it can be of great assistance to you and provide you with the opportunity to integrate multiple data sources for searching purposes. You can easily access this tool through our website, and the actual link is attached at the bottom. Okay, the next slide, please.
Thank you. Where? Come on. There we go.
Okay, so we have assistance centers for patents and for trademarks. So there's a patent assistance center and a trademarks assistance center. And this Inventors Assistance Center will help you come to the realization or help you identify exactly what you need and what the resources are that are available to you that might provide you with the support that you need. So you can call these numbers and you can get a person at the other end to provide you with answers to questions and queries that you might have about the process. These slides will be sent out to everyone after the recording is done, and you will have access to the links and the phone numbers, and you'll be able to utilize these tools as soon as you get the presentation. So the Inventors Assistance Center answers various questions regarding patent examining policy, questions that are directed to formats and items needed for your application, It assists you with forms that you need for filing your application. And it can also provide you with personnel at the USPTO and web pages as necessary. It'll provide you general information concerning the rules, the procedures, and the fees that are directed to filing an application, and information and forms via the United States Postal Service, mail, or facsimile. We strongly urge you not to mail things to the USPTO, but to use our electronic filing system. To mail things in, you would incur a greater expense than if you're able to access things electronically. I'm ready for the next slide. So as I stated, there is a trademark assistance center and there's a patent assistance center. So if you're looking to brand a product, or you're looking for brand recognition so that you can use some type of identifier for your business or for your product and the like, then you want a trademark. And I'm sure that Kimberly has gone through that and has reviewed what trademarks are and what trademarks cover. And so as you move through the process towards a trademark, you made the decision that the trademark is a type of intellectual property that you need or that you're desiring, then you might need assistance from the Trademark Assistance Center. If you hit a roadblock or there's something that you have a question about that you're unsure of, these are some of the most informed and nicest people at the United States Patent and Trademark Office. They are a favorite of the Detroit office, the Midwest Regional Office, and we always look forward to engaging them and asking questions. You can ask the questions of us. A lot of times we'll ask the questions of them. You can bypass us and go directly to them and get your questions answered. Following this Trademark Assistance Center slide should be a Patent Assistance Center slide. Nope, we don't have that, but I do want to identify and let you know that like there is a Trademark Assistance Center, there is a Patent Assistance Center. Now, one of the tools that I want to really bring to your attention on this resources page is the IP Awareness Assessment tool. This tool will help you determine whether or not you want a patent or a trademark. And it's very important that you go in and that you figure out exactly what type of intellectual property you're seeking protection for, because your time is valuable, your money, you want to spend it wisely, and using this type of tool will help guide you and provide you with the foundation as to where you need to go and how you need to move about in the intellectual property space to get the best protection and to get the most out of the resources that we have at our disposal. Pro se assistance is also on this page. This is assistance for someone who is attempting to move through the intellectual property space without the assistance of an attorney. And we always recommend that you get an attorney. Patent pro bono help, you may want to go in and look at that to find out whether or not a law firm or an attorney might want to provide you with free services that would allow you the opportunity to have support in filing and seeking intellectual property protection. There are law school clinics throughout the United States associated with major universities that have law schools. And these law school clinics allow you to go into the clinic, and there is a person who is licensed to practice before the USPTO bar, and they can provide you with support, with the support of a student who is interested in intellectual property, who would work with you to help you in your pursuit of intellectual property. Let me see, is there another utility patent application guide is what you would use if you were filing an application. And if you have any questions about any of these resources, you can always reach out to the Midwest office and we will provide you with guidance and we will assist you in making the best decision as to whether or not there is a particular tool or a particular resource that would be of most interest and most helpful to you. Where to find these programs? On our website. And you can find programs that are going on at the USPTO that include presentations and seminars and various other events that might be going on with the USPTO. And it can be found at the website that you see right there on the screen that's underlined. And you can subscribe and have updates come directly into your email box. I know a lot of people say I get enough emails, but these emails will keep you abreast and apprised of the activities and the events that are taking place at the United States Patent and Trademark Office that might be of interest to you. Non-USPTO resources for businesses include USSBA, the United States Small Business Administration, who we have a partnership with and who we collaborate with in providing guidance and support for our various stakeholders. SCORE is a subset or an organization that provides support to those who are starting budding businesses and small businesses. There are local incubators and accelerators that provide support also for those who are looking for guidance, business support, and financial support. There are inventors organizations that provide so much information, just like the one that you are a part of in participating with this event, and state resources such as SBDCs that, even though not USPTO, they're not USPTO resources, they actually serve and we work with them in collaboration to assist you in advancing your entrepreneurial efforts. If you have questions about anything that's been presented here today, please reach out to us at www.uspto.gov/Midwest. That comes into a generalized mailbox, and we will go through and answer your question directly to you. We don't share email addresses and things like that. Your questions are kept confidential because they're your questions. And we look forward to hearing from you should you have any. We have a Facebook page and we have YouTube videos that provide all manner of support and guidance with regard to how to file trademarks and how to do various things that you might seek information about regarding the USPTO. If you have any questions, please feel free to put those in the chat. Myself and Kimberly will do our best to provide you with any answers. The pro bono information has been placed in the chat by none other than Carolyn Stivers. And the Inventor Search Assistance tool has also been placed there. The slides will be coming to you. And if you have specific questions that you may not want to ask now, or that you may not want to advance in this forum, then do feel free to email us at the email address that's directed to the Midwest mailbox, where we can engage you and provide you with support as best we can. Thank you for this opportunity. I apologize for the trouble that I had with getting online. I left the meeting and thought that I would be able to come right in here, click on things, and not be front and center, but it doesn't always work that way. And so I've learned a valuable lesson that I'll be trying to get on 15 to 20 minutes before so that I can get it figured out and I can be on. I always enjoy coming and discussing with this group, and I hope that we get an invitation back. And if you need something specifically with regard to what we can provide in the way of resources or information, please don't hesitate to reach out to us. Caroline is a part of our family now because she has come to us and has provided us with access to you. And we look forward to providing you all that you need that the United States Patent and Trademark Office can provide. Kimberly, I know that you did an excellent job. I know that you were able to cover for me, and I owe you.
Thank you, James and Kimberly. It's great to have you all both here today with us, and that was a great presentation. So we do have a couple of questions that I can start if you all are ready for those. The first one I think was from Kimberly's section. Is the difference between copyright protection length decided by the filing structure, or are there other factors at play?
I'm not sure that I understand the question.
So I think, and Connor, if you want to clarify, I can unmute you. But I think with my guess or on this one is with the copyright being much, much longer. Yeah, so the 70 versus 90 versus 100 years.
Okay, the difference in the amount of time.
Yeah.
I'm not sure what the parameters are. Copyright protection extends beyond the life of the person who actually is filing for it. And there are some specifics with regard to that. I can get back to you with a more detailed answer. We are Patent and Trademark Office, but we can get answers to you from our copyright expert. The Copyright Office falls under Congress and the legislative branch, and the United States Patent and Trademark Office. We advise the executive branch, the president, on copyright matters, but we actually leave copyright matters to the Copyright Office. So I will, if you submit that to us under the www Midwest email address, I'll get a detailed answer back to you expeditiously.
Thank you, James. And I think we're also hoping to have a kind of copyright basics later this year, so everyone kind of stay tuned for that. Okay, the next one I see in here is, can the USPTO help me decide if I should patent or trademark something?
Absolutely. The IP assessment tool that was on the resources page that I pointed out is the tool that you would use to make that type of determination. It would provide, you would go in and you would answer a series of questions, and it will provide, and you say whether or not there's one or the other, it might recommend that you do both. So we want to make sure that you get the accurate intellectual property protection that you need. It will tell you and provide you with some guidance as to whether a patent would best protect your intellectual property, a trademark would best support your or protect your intellectual property, or both.
Okay,
Good
thank
question.
you, James.
Good question. Good question.
Okay. The next one I'm seeing, do discussions with a USPTO employee constitute prior art if we seek in-person assistance from the office regarding patentability?
Things must be published and made publicly available to qualify as prior art. So conversations with USPTO employees, first, they're confidential, and we can't discuss what we discuss with you. And secondly, if you don't publish it and you don't put it out so that it's available to someone in the public, then it's not going to constitute prior art. When you go out and you discuss intellectual property matters that involve you, if you're going to talk to somebody who might be interested in securing and or providing support to your intellectual property, you might want to look at a non-disclosure statement that would allow you the opportunity to talk to somebody, but they're not at liberty to talk to anybody else about what you discuss with them. So we are bound by law not to be able to talk about what you discuss with us. But if you talk to someone in the public, or someone else who owns a business, or someone else who could take your invention and file it before the United States, or submit a registration application for a trademark, you place yourself in danger of losing your intellectual property. So make sure that you protect yourself with non-disclosure statements. And you can look those up on Google. It'll give you a really good explanation and idea of the type of preliminary protection that you need even before you file a patent or a trademark application.
Great. advice for everyone to consider as you all are moving forward in your journey too there. Okay, the next one I'm seeing, and then actually I've got kind of two that are related. So I'll start with one. Can you elaborate on the cost associated with the patent versus copyright versus trademark?
Okay.
So general
Oh,
ranges on those.
okay, so we as patent examiners and as administrators, we are a little removed from the fees and the how much things cost, but we can provide you with those schedules. Patents, I would venture to say, are more expensive than any other type of intellectual property that you would file for. Then I believe next in line would be the trademarks. And then last and least expensive would be the copyrights. And a lot of these things are contingent upon what your invention is or what your brand is and what you want to put your brand on and how many different classes you're going to use for branding because you pay for those different classes that you would employ to secure trademark protection. And copyrights are a little bit more straightforward and a little bit more simple. You know, your invention of your mind or your creation of your mind when it comes to copyrights are copywritten even if you don't register them. So I would just want to keep that in mind. You know, something that you write, a song, a painting, a sculpture, it's copywritten once it's fixed. But to register it is to gain an added level and layer of protection. So I would say patents are the most expensive. The next level would be trademarks, and the last level would be copyrights. In general.
Okay, and then the last one I'm seeing right now, kind of related and on that same vein of things, is there any resource to help cover the cost of fees related to filing a patent?
Well, the way that you help yourself in those instances is you seek or you obtain pro bono services where attorneys provide you with assistance and they don't charge you, or you go the pro se route, which means without any type of legal assistance or support, and you learn the system and you move through the system as an individual. We do provide some level of support for those who are seeking to do a pro se application in patents and trademarks. And we will provide you with some support, but it is a very, I don't want to say difficult. Yeah, it is difficult. It's difficult and it's complex to file a patent application, which is why attorneys make a whole lot of money assisting those who are desirous of obtaining that level of protection for their inventions and for their registered trademarks.
And another thing to add is if you're a small business, there is a different fee schedule for small businesses versus large corporations. So the fees are generally maybe half or I don't quote me on half, but they're significantly less than a large corporation who is filing a patent application.
Thank you, Kim.
Okay, that's the last question I'm seeing today. Did you all have anything else to wrap up?
Just want to say thank you for this opportunity. And we hope that we provided you with some answers to questions that you might have. And again, please feel free to make sure that you reach out to us via email if you have a question that you didn't want to advance here, or if a question comes to mind later or subsequent, or as you're going through the presentation and you flip through it and you want to know something that we didn't articulate on or go as in detail or in depth as would be preferred for your knowledge and for your purposes. On behalf of Damian Opakari, the director of the Elijah J. McCoy Midwest Regional Office, Kimberly Ballard and James O. Wilson, want to thank you again for this assistance. As I said, Carolyn Stivers is a member of our family. So when family members ask us to come through, we come through and provide the level of assistance and support that we can to help you have a better understanding of your IP needs and your IP desires. Carolyn, thank you so much. Thank you for being patient with me in my inability to get online today. And we're going to work our way through all of this.
Yes, and thank you, James and Kimberly, for hopping on. And yeah, thanks. Sorry again for all the Zoom issues, but definitely appreciate your all's time today and taking the time to present to our Kentucky community. It's always great to have you all, so appreciate it. But yeah, thanks again. Hope we can have you all back in the future. I will be sending out slides to all that attended today with all the contact info on it, where you can reach them or reach the Midwest office. So thanks again, everyone, for joining, and hope you all have a great rest of your week.
Thank you, Caroline.
Thanks.
Everybody stay safe.
Thank you, you too.